we had a lot of discussion, opinions about what's happening in the higher courts, but not the district courts. And as you will hear today, there are a lot of challenges over there, and there's a lot to be done as well. The speakers are Prashant Reddy and Chitrakshi Jain. Prashant Reddy is, both are trained lawyers, but I think neither is a practicing lawyer as of now. Prashant Reddy did his law at NLSUI in Bangalore, and then in Stanford, and then he's worked in Singapore in law firms like called Coffee Cut, and it's basic, yeah, and another on it's called The Truth Pill, both co-authored books. Chitrakshi is also a lawyer. She did her law here in Nalsar. And then, interestingly, she went to JNU and did her MPhil in political science. And has worked in civil society organizations and is now working in Trustbridge Foundation. Am I correct? Yeah. So she's basically working in the not-for-profit sector on issues relating to the law. So both of them will speak about their new book, which is also available for sale, if you would like to pick it up after the talk. Prashant, Chitrakshi, please.
I'm very grateful. So this talk is about a book which is titled Tariq Pe Justice, Reforms for India's District Courts. Yeah, so just for some context on the title, because we realized that a lot of younger people weren't getting why we named it Tariq Pe Justice. I'm sure the older ones amongst you know of the famous dialogue of Sunny Deol and Damini, where he screams out at the court when the judge is granting another adjournment, saying, "I said Tariq Pe Tariq mil raha, my lord, insaf nahi mil raha." And that dialogue has become so iconic that it has crept into into policy documents, into judgments of the courts. Every time a person is frustrated with the legal system and its failure to deliver justice in a timely manner, this dialogue has made its way into that particular document. So that's why we chose the name of the book. Now let me get into the subject of the book. The three-tier system. You've got the Supreme Court at the top, then you've got the High Courts, which are the highest courts within the state, and then you have the district courts. The district courts are a three-tier system. For example, you have a district judge, you have a civil judge, senior division, civil judge, junior division, and then on the criminal, these here are only civil cases, and then on the criminal side, you'll have the sessions judge, the chief judicial magistrate, and the judicial magistrate first class. Now, the district judiciary is the first point of contact for most litigants in the country because these courts are present literally in every district. They deal with the largest load of litigation in the country. Most of your cases will not even reach the High Court. All your property disputes, contract enforcement, matrimonial cases, bail cases, they all start before the district judiciary. And crucially, the judicial magistrate first class, although he's at the bottom of the hierarchy, is perhaps the most important person when it comes to protecting your civil rights and civil liberties. Because when a person is arrested, he has to be presented before the judicial magistrate within 24 hours. And the judicial magistrate then has to decide whether to give the state remand of this person or let him out. So this is, and apart obviously from criminal cases where they're deciding the life and liberty of people on a daily basis. So this level of the judiciary, despite its importance to our daily lives, actually gets very little attention. Whether it's in mainstream media or even within legal academia, there are very few people actually studying it. When we were researching for the book, we found maybe about one or two other academics who are looking at some of the issues pertaining to the district judiciary. So our book is focused entirely on this layer of the judiciary. We're not looking at the High Courts and the Supreme Court. So now let me begin with the argument that we're trying to make in the book. Now traditionally, any kind of conversation that we have on the district judiciary and its failure to deliver justice, it's always been framed funds. Now, our argument is that this actually isn't a problem. For example, what matters actually is what is the methodology that you're using to calculate the number of judges. For the last 20 years, the Supreme Court has been using this methodology where they're trying to calculate the number of judges by pegging it to the total population, by pegging it to per million people in the country. And they continue to do this despite their own expert reports. These expert reports commissioned by the Supreme Court. There's a law commission report which has said that population should not be the metric as per which you calculate the number of judges required. Because if you just take, for example, the city of Delhi, which has 20 million people, and you take Bihar, the state of Bihar, which has 100 million people, civil litigation rates are higher in Delhi than in Bihar, which is because of the fact that litigation and caseload before courts is not guided only by population, but by wealth of the society, by the other economic factors, what is economic activity happening in a particular society. So these are all factors that contribute to the volume of litigation that is taking place. So Supreme Court, the successive Supreme Court judges who continue to cite this metric of judges per population without understanding that their own reports have completely discarded this method. So the right way perhaps to calculate the number of judges is looking at the caseload that is there before the courts. The problem here now is, despite having spent about 2,500 crores to build the National Judicial Data Grid and the digitization program for district courts, we still don't have accurate data. I'm not getting into the details of this, but the only good news is that this 5 crore figure that you hear in the media of pending cases before the district courts is likely very exaggerated, because there's a problem with how cases are being counted by this National Judicial Data Grid. And our estimate is that the cases are actually far less than that. The larger problem, however, is the inability of the judiciary, especially the Supreme Court, to inculcate a culture of transparency within the judiciary, because statistics is all about transparency, right? And it's tragic that when we were researching for this book, we found better statistics from 1879 in the Madras Presidency, because the British state was doing a much better job of collecting judicial statistics than we can find for in India in the last 10 years. So we don't have, because we don't know the number of cases pending, it's actually difficult to calculate whether we are actually running short of judges or not. But on pure statistics, like I said, the statistical fact is that the number of judges in India has increased almost threefold at the district court level. So in 1987, we had about 7,675 judges. Now we have about 21,000 judges, another 4,000 posts are vacant. So it has tripled. And in addition, judicial capacity has increased, because what the government has done is they've created debt recovery tribunals, for example, which has shifted a lot of litigation that banks used to have before district courts to these specialized tribunals. So in that sense, judicial capacity has increased. So there has been a political willingness to hire more judges, create more capacity, and we've also seen Parliament pumping funds over the last 20 years. About 10,000 crores for judicial infrastructure, 2,500 crores for digital infrastructure. So all this money is going in, resources are increasing, but nothing is changing on the ground. And we are trying to explore other reasons as to why perhaps this may be happening, and why there's been no substantial change in the pace of cases and the speed of disposal before the district courts. And one of the issues that we wanted to look at specifically is the issue of judicial independence. Now, traditionally, when we talk about judicial independence, we are looking at it from the perspective of the Supreme Court and High Court, and how independent that they are from the executive arm of government. But there is another aspect of judicial independence, which is what we refer to as decisional independence. That is a judge confident enough of delivering a judgment without having to fear consequences for his career after doing so. Now, the district courts have fear within the district judiciary, but he does not explain where that climate of fear is coming from. Which an ordinary listener, they think that perhaps the judge is afraid of the government, but no, they're actually afraid of their own peers within the judiciary, and that is generally the registrar vigilance and the High Court judge. in such a way that the accused need not have to remain in custody for any longer period. And hence, we presume that we've indulged in a corrupt practice. So again, the facts in this case were the judge didn't follow a minimum sentencing requirement in the law. So under customs law, there's a specific punishment of certain number of years that have to be granted to people caught smuggling certain items. In this case, the judge basically said that whatever time you have served, that's sufficient. I'm not granting the minimum sentence prescribed in the law, and this is very common. I've seen this happen in the pharma industry multiple times. The law says minimum 1 year you have to go to jail if you manufacture substandard medicine, and you see number of cases where judges award simple imprisonment till the rising of the court. So it's not a big deal not following a minimum sentencing requirement, and this could also have been rectified on appeal. But this and another charge, which we don't have here, were cited to dismiss the judge from his job. He lost his job because he was lenient in sentencing, and there was no corruption in this case or the previous case. There was no evidence of actually money having exchanged hands, because the way the charges are written.
They are subjected to an assessment which is based on their character, their integrity, and most importantly, each high court has devised a unit system, which is primarily a quantitative weightage given to each task that is supposed to be performed by each judge. So, for example, if you go to the next slide, if a judge is examining a certain number of witnesses, for each witness, they get a certain point. So, they earn units in discharge of their judicial functions and even for administrative tasks. And the unit system methodology, which is prescribed by each high court, also mandates that each judge, depending on the cadre, has to attain a certain number of units to get certain ratings, which are average, below average, good. So they will have a time period in mind. So either this unit assessment is done quarterly or annually, and they need to then show that they have in fact earned these number of units which are prescribed in the unit system methodology by each high court. Now there are certain drawbacks with having such an approach, which forms the basis of their annual confidential reports and the ratings that they get in these performance assessment mechanisms. It's quite easy for the judge to game this system and make sure that the easier to hear cases are then decided so that the judge earns the required number of units to get a good rating. So the way it translates into action is that there are cases which are which are lengthier, which involve more witnesses, are probably heavily contested, and the tendency of the judges then is to make sure that they dispose of the easier cases first, get their ratings, and get the required rating in the ACR, which is good, to get their career progression on time. Yeah, this is going to the next slide. Yeah, so they have these ratings where you get a certain number of units, you will either be awarded poor, below average, average, or good, and they need to get a good rating. And this affects their promotions not only in the near term, but also in the long term. And why? The first drawback, of course, is that it makes sure that all the heavily contested and more difficult to hear cases are pushed into the background. The other drawback of such a system is that these ratings that these judges earn during their annual performance reviews are then used to compulsorily retire them when they have attained certain milestone ages. Now, the district judges are subjected to this very particular administrative practice of compulsory retirement, which is in fact, in terms of time, is a relatively recent introduction. It was introduced through a Supreme Court judgment in a litigation by the All India Judges Association cases, where the Supreme Court directed and formed a Shetty Commission, which looked into the service conditions of judges and then later prescribed that there is a need to separate the judges which are not very competent, and this mandatory review is then conducted at certain milestone ages of 50, 55, and 58. In Gujarat, for example, as soon as the judge turns 50, they would be then subject to a mandatory performance review, in which any adverse remark which is present in the ACR can then be used to justify their order of compulsory retirement. Now, why this is particularly problematic is that when the High Court issues such an order, it is not bound to give any specific reasons for this. The judges are made very vulnerable by the practice of transfers. And it would make sense if there was a rationale to this practice. Now, most of the High Court transfer policies do not really articulate what is the purpose of transfers anymore. So they do not say, for example, that it is so that judges remain impartial. There is no indication what is the purpose of these transfers, especially given that they are fairly regular. They have an annual transfer inter-district sometime in the monsoons, depending on the state. For example, in UP, it is sometime in September, October, and their portfolio keeps changing. There is no rationale given for this practice, and it has been served by these transfer practices. The other problem is that there is always commonly, especially the bar is aware of the fact that there are certain districts which are considered to be punishment postings, and there are certain sought after districts where all judges want to be posted at. Now, in some jurisdictions, for example, Kenya, which was also formerly colonized by the British, their transfer policies clearly indicate that the litigant has a right to have equal access to competent justice. And this makes sure that at least transfers are not really used as a tool of punishment. Since this process is also done very intransparently, we are not sure if this is not being used as a tool for punishment, where judges who are seen as either incompetent are sent to postings which are not very lucrative. And this also compromises the rights of citizens to have access to competent judges, because you will have probably better judges in the state capital and maybe not so much in the districts which are far off from the state capital. Again, the rationale for these policies is not clear, and combined with all the other administrative practices. So think about the unit system that we just spoke about, which is already incentivizing judges to deal with the easier cases fast. Then you have an incentive in the form of you are aware that there will be a successor who will take over your caseload. And you can easily make sure that the complicated, lengthier cases are then transferred to that judge, and you are transferred out to a new district where you will have a new caseload. What these practices are encouraging is that they are making sure that older, lengthier cases are just pushed into the background, and this is really harmful for the efficiency of the legal system as a whole. So when you're designing judicial policy, especially an administrative practice like transfers, you cannot really prioritize a lot of the people argue that transfers also expose judges to better. So, for example, if you're posted to the state capital which sees more civil litigation, your career growth will be immense in that period. But perhaps it's not fair to then think about transfers as a policy which is used as a way to mold that judge into a better judge. You need to think about all the stakeholders in the legal system, especially the litigants, and make sure that there are competent judges being selected in the first place. And then you also have a permanent docketing system so that you know that that judge is committed to that particular.
The salaries, and why do I want to take the risk? I'm very happy with what I'm doing. So no one wants to take a chance. I didn't expect that the judiciary is also an aspect of it. I mean, if there's an overhanging fear of bail, of giving bail, you don't need to find the reason. That fear is there. And the litigant is obviously at a disadvantage. So I must thank you for helping me to change my view 180 degrees from what I thought it was and what it is in reality. Thank you very much for that.
Thank you so much.
Yeah. Questions?
Issue tribunal, and the idea was that there should be less of a burden on the High Court and the Supreme Court. But in one or two cases, Supreme Court and High Court have decided, even if it goes to tribunal, that is again appealed again back in the High Court under Article 226 or 32 of the Supreme Court. The whole objective has been lost because the entire thing again same burden is there in the High Court. That's one aspect. The second aspect is, I find that in the appointment of tribunals, what is very important is that they should have a specialized knowledge, an expert knowledge in the field. That must be named, but the law is so framed that we have done public service and we have done this, that and all, you can get in. That doesn't mean that you have the expertise for suddenly developing. You have got to develop it over a period of time. So it does not really mean that the law itself has to change, that only experts in the field should come in and they should form the bench. Otherwise, the whole
The problem is the way the selections are done in India. Even if there are people with specialist qualifications, they're often not appointed. But a larger problem is a lot of these new areas of law, there just aren't enough people with adequate experience in the country. Because when competition law came in, it was such a new field. So initially there was no, you didn't have enough experts, lawyers or academics who could be appointed. As a result, IS officers, etc. were being appointed. So that is one problem, but yes, ideally you would want better specialists on these tribunals, and that involves fixing the entire appointment process of for tribunals, which is, we can write another book on that. It's completely broken and it's opaque. On your first question regarding creating tribunals and then bringing it back under the control of the courts, I mean, so there was a unique set of circumstances. This happened, I think, in '97 in the Chandrakumar case, where the Central Administrative Tribunal, the Supreme Court, said that the high courts, you can approach the high courts under the Article 226 jurisdiction. But the reason for that was because the way the government drafted the law, they said you file your case before the CAT, and then after that, your only option for an appeal is you have to file a SLP, a special leave petition, before the Supreme Court. The Supreme Court was flooded with litigation. The ideal way to have done it is to have created one layer of an appellate body, because all litigants are given at least two bites at the apple. Right? So they didn't do that, which is why the Supreme Court then had to, it was a reflex reaction because they were getting flooded with SLP. So which is why the high courts then again had to get back jurisdiction over these tribunals. But not all tribunals are functioning like.
Can I just ask one?
Yes.
Small supplementary, small one.
So, unfortunately, high courts are so opaque, they don't release statistics proactively on how often disciplinary inquiries are happening. So, we had to RTI this information. 5 high courts gave us, I think we asked for 15, and maybe 5 high courts gave us some information. Over a span of 5 years, there have been 198 disciplinary inquiries initiated just by 5 high courts. So, this is not something that is happening on a one-off. The frequency appears to be quite worrisome. And when you combine this with how the performance assessment system works, where judges, high court judges can enter an adverse entry into the ECR, saying integrity doubtful. All of this contributes at the end of the day to a climate of fear. Even it's not our case that corrupt judges should be allowed to go scot-free. We are just saying you better have better investigation and ensure that the disciplinary process is more transparent. For example, why is it now that a High Court judge is accused of corruption in this Justice Verma case? Everything is going to happen in the public domain once the impeachment process starts. Why can't we have the same thing happening for disciplinary proceedings before, for the district judiciary? Let the entire process play out in public. We are in a situation now where a judge is dismissed, his review petition before the High Court is dismissed, and they still will not give us a copy of the inquiry committee report. So the idea is, what we are asking for is build a system that is transparent and fair and builds confidence in all the participants, including the judges. And if there is a corrupt judge, go after it. But there has to be a reasonable standard, because the moment you let these standards slip and say that on a whiff of suspicion I'm going to start dismissing people, we land up in a situation where we are today. The judges don't want to grant bail after or decide certain kinds of cases. I think Punjab, Haryana, Gujarat, Bombay High Court, two more, sorry. You want to ask? Yeah.
Good evening. Department of Justice, which is jointly responsible for the judicial data grid. So the correct way to go about it would be to make sure that they disclose the parameters. First of all, revise the parameters on which they are collecting this data, and also make sure that they are attesting to the verifiability of that data. Because currently there's a disclaimer on the website which clearly says that these statistics should not substitute for the actual data collected by the courts. So when you are publishing statistics, the first step would be to make sure that you authenticate that data, and the second would be to make sure you're collecting the right data. So currently, not only are cases being overcounted, we don't have a right way of measuring how much time is spent by each judge on a particular category of case. So we don't have a proxy for how to measure the complexity of a case, and therefore how much time is required to decide a case. and therefore we don't know what the ideal timeline should be. So the kind of data that is collected, and then the second thing would be to make sure that the way you collect and publish data is authenticated. This can be easily be made. They can be asked to mandatorily do this through a law.
And just to add to that, there was, 22 years ago, there was a law introduced by the late Pali Nariman, when he was an MP in the Rajya Sabha, called the Judicial Statistics Bill, where he had clearly outlined the types of data, etc., that has to be captured. And the backdrop to his bill actually was a discussion in Parliament between Mr. Jaitley and Mr. Sibal, in that high courts are just refusing to give data. They're invoking some certain constitutional privileges in Article 121, absurd reasons, and saying that we'll infringe on our independence if we give this data. So there's also a power issue over there, where high courts don't want to become more transparent. So the only way to mandate this is for Parliament to bring in a law wherein they are mandated to present certain data to statistics to the government or to Parliament every year to ensure that that the data is true and it's done on a regular basis. Yes, sir.
The most important point in all the discussions what we are having is to see that the justice is neither delayed nor denied. So whatever you have brought it out about the independence of the judiciary, frankly, it's a lot of enlightenment to us. So it's not always that the justice is delayed and denied for any different reason. It is also because of the independence of the judiciary or the fear and those kind of things. But in many cases, we see it is neither the independence nor the issue of fear, nor that they are corrupt, that the justice is delayed and denied. So there are cases where in the city civil courts and the district courts go on for years, and several adjournments happen, and in the process the justice is obviously delayed, and none of these reasons are the cause for that. I don't want to name or anything like that. We have a case against an insurance company. It is neither government or anything like that. Even in this case, even the insurance company is interested to settle the matter quickly. But the case is there. We had a fire accident in 2013. Now we are in 2025, and so the matter has been there in arbitration. Now in the city civil court, it has been there from 2019, last 6 years. It has only been adjournments and adjournments and adjournments. And finally, the case has been heard about a year ago. After so many adjournments, and matter went back to High Court, because we went to High Court and asking them to direct the city civil court to hear the matter quickly, and then city civil court heard the matter, and then the judge reserved the judgment after hearing the matter. Then he is transferred.
See, we gave the extract.
No, here it is not the case of independence. No. Here it is not that anybody has a motive to transfer him because of this case, or this is a small case.
The question to ask
people
is
that
why?
way. Yeah.
Why do we have these insane transfer policies for judges? Right? Because litigants like you are suffering. Why transfer judges? And if I can give you a certain explanation on why perhaps your case kept getting adjourned, is because of what Chitrakshi explained. The judge is sitting and counting how many units do I need for this quarter to get a rating. Your case may have been a bit complicated, so he's found about 10 other simpler cases and decided, okay, I'll decide these. I'm just going to adjourn this. Neither party lawyer is really pushing it, so I'm just going to keep adjourning it and until I get transferred. Which like you perfectly explain what happened to your case right now.
But understand, but the case here is that the kind of adjournments, can there be a situation or can there be a law, something like that, you can't accept more than 5, more than 10 adjournments or anything like that?
The Order 17, Rule 3 of the CPC says not more than 3 adjournments. They introduced this in 99 and 2000.
But nobody follows.
Nobody follows, right? Exactly. That's the problem. And human behavior cannot be regulated just by one rule in the book. You have to look at what the incentives are for individual judges. And that's what we are trying to explain. How the incentive system works out for them.
And the incentives are for the lawyers, because lawyers also are charged with all appearance fee. So we have only looked at one category of legal professionals. professionals, but there is litigation culture which also has to be reformed.
I agree, but since you said that not more than 3 adjournments, there is already a law, and if it is not followed, then what is the remedy?
Technically, it depends who's asking for adjournments. So your lawyer technically can move a motion if the other side has asked for 3 adjournments. Asking for the case to be proceeded ex parte. That is, the judge just has to hear arguments without the other side. But if your lawyer moves that motion, the judge accepts it, the other party will file a complaint against the judge. And then we fall back into what we exactly explained right.
No, but here actually what happened, I'm sorry to extend another 1 minute. Actually we filed that, our side. And then the ex parte judgment has been given by the citizen court in our favor. And then the insurance company went to the High Court. Not that they are interested to go, but they are public servants, so they can't accept that. So then the High Court gave a directive, reverted the case back to the city civil court to hear the case again, to give some opportunity to the other side to present themselves. Again, adjournments.
So our book ends at the district court. High court is a different law.
About an Allahabad High Court judge with whom I had dinner, and I was told that he was a very fair judge. Let me tell you what his fairness is. Every time there is a complicated case, he calls both the petitioner and the defendant's advocates to his chamber and collects equal sums of money from them. On the day of the judgment, after the judgment, he returns the money to the counterparty who lost. I think in corruption, he's been very fair.
Station, it's easier to manage the SHO, and the SHO will get this done faster than going to court. The other form that we see where people have decided to bypass courts are encounter killings, where policemen are, killing people in cold blood without a trial. Third form we're seeing is bulldozer injustice, where we're using bulldozers to take care of issues which bureaucrats just don't want to go to courts for. So that crisis of legitimacy has already enveloped the system. The only question is how much lower can we go from here? I think we're close to the bottom. Perhaps I've been proved wrong. And changing this situation it's very difficult, because this issue is just, when it comes to talking about the judiciary, the High Court and the Supreme Court are the sexy topics. And this is the largest turnout that we have ever gotten for one of our book talks. So thank you all for coming. But otherwise, speaking about district courts and getting a conversation going on reforming district courts is very, very difficult. And we're talking about changing a system that has been in place since about 1875, 1860s. So the inertia in the system is a lot. And just getting that conversation started, reforms are good ki baat. First, we at least have to start, get that, having that conversation in our circles, in the media, etc. to get that steam going. And traditionally, political parties have stayed away from judicial reform unless it's on the issue of, appointment of Supreme Court, High Court judges, because that's a question of political power. I'm not very optimistic in the near term.
Yeah.
Hope I didn't kill the buzz.
Yes, sir.
Of a system that is clearly biased and where High Court judges have judicial levers of power. This is an open, it's an open invitation for abuse and undermining elected government. I'm definitely not in favor.
Yeah, last question.
Hi, I'm Vishnu. Thank you very much for giving me an
Judge, which is perhaps not fair to the judge who is being assessed. So if we make sure that the bar is involved and their peers are also involved, at least the abuse in terms of the subjective assessment will go away. Of course, it is also hypocritical because the higher courts are not subjected to any performance abuse. So we can perhaps start from there. There is no equal footing there.
Using the performance assessment we are very against this idea of giving more carrots to the judge for, for a promotion or for a better posting. So the idea of a performance assessment in the judicial context should be for the judge to improve himself. Because they're sitting on the bench, they're just used to people deferring to them all the time. There's no feedback loop on how they can be wrong and terrible, that behavior can be terrible on the bench. So an anonymous feedback loop from the bar and code stuff can help a lot in trying to fix some of these. More character improvement than accountability. System, right? Every lawyer, every judge will complain the system is corrupt. You ask them, have you ever paid a bribe, received a bribe? They'll say, I've never paid a bribe.
Another thing is, some judges are branding for the granting bail, some are not. So there is, what is the role of the merit of the case? Have you comment on this?
I'm sorry, I didn't understand.
So some judges are branding for granting bail, some are not. If the case goes to the XY judge, you will definitely get bail. Otherwise, some people are branding for not, they will not give the bail. So where is the merit of the case? I don't understand it.
Yeah, I mean, that's a problem, right? Because of some of the issues that we discussed here. Some judges are more afraid of granting bail because they're worried of an inquiry. Maybe some judges are corrupt, I'm not discounting that. That's completely possible. But it's impossible to give like a single answer to your question. There'll be 1,000
My name is Ram.
Nobody agrees with that.
Nobody agrees with it because, of course, after Nanavati case, 8:1, nobody is actually holding that in the current scenario. Maybe in future, hopefully, and especially when the scientific knowledge comes into picture. The concept of unit system, like I've been doing it day in, day out. Unit system is a point of assessment which comes only to aid the number of filing, which on the judicial data grid there will be different numbers which are updated. A same case will have 100 petitions filed, even they are updated. But every month a judicial officer sends a statement to the district court, which is then forwarded to the High Court and then goes to the Supreme Court committee. So a district court officer actually analyzes how many criminal petitions are filed, how many IAs are filed, how many miscellaneous petitions are filed, how many are decided out of that. And after how many are decided, a unit assessment is made. And not every assessment has a unit. Only something which is going to have right affected of a party, like Order 7 Rule 11. A party who has filed a case, his entire case goes away. Now that is a big order, an injunction application. Somebody's liberty is curtailed. Now these are the concepts which are there in civil side. But in criminal side, there are no units like what you are telling, 1 unit, half unit. Rather, it's incentivized. If you deal the old case, you get 2 units. If you deal a new case, you get 1 unit. So the concept is more of disposing the old cases right now.
But it's not uniform across states. Which state are you talking about?
I was judging this state.
But it's not uniform across states.
Yeah, it's not state, and I have my batchmates all across. So the concept with respect to ACR, it's 2 ways. There is a quantitative assessment and qualitative assessment. The qualitative assessment is when we every month send the judgments which it has. It analyzes those judgments with respect to application of law, appreciation of evidence, appreciation of facts, marshalling of facts. These are the criteria which has been there since time immemorial. And this is what the British has also laid down. Even if you read any treaties on civil adjudication, this is what it lays down. So the same parameters we have. How do we marshal a fact? What are the possibilities? Whether the circumstantial evidences are examined properly. Whether the conviction is based on this.
How fair are High Court judges when they're doing this assessment?
Sir, they're fair. I know my reports. Can't comment on others. So they're fair. But when these assessments are made, it is not just the High Court judges who makes an assessment. Even the district judge assesses it. Then it goes to the High Court for second assessment, and then it portfolio. And after the portfolio, it goes to the committee. So the entire assessment is qualitative and quantitative. So once your qualitative is high and quantitative is low, still you get a very good. Once your quantitative is low and qualitative is low, then you get poor. So there is a balance which the system is trying to make internally as to, okay, there is pendency. Multiple stakeholders are involved in pendency, not just the courts. The advocates want time because the delayed the cases, the more adjournments, the more fees. Similarly, police will not bring the witness just because there is going to be an apprehension that he will turn hostile. Similarly, public prosecutors are not there in half of the courts that you see. So when you see all these assessments out there, it's not just the case is being heard by the judge. It's also because you can just now go to any court right now. The public prosecutor comes only on Monday and Tuesday, but the pendency is 7,000 criminal cases. So on one day, on 2 days, how many cases can the judge hear? So all these contributing factors also affect the performance. which even the high courts and the district court and the trial courts are also very mindful that okay, that court does not have a public prosecutor, he is not able to attain so and so units. So every year when our ACR is sent, there is a line which says that no permanent public prosecutor assigned to this court. And then it passes on. That year is not assessed. That entire year is not assessed in the entire aspect of assessment. So the unit system in a way is both incentivizing, at the same time it does create pressure when you have a lot of cases and you have a lot of high court directions and you have a lot of Supreme Court directions, and at the same time, if you understand the life of a magistrate or a judge, like he sits at 10 o'clock and he gets up at 2 o'clock. That's the time. 2 to 2:30 is his lunch. Again he sits at 2 to 6 he sits.
So then don't sit after lunch.
Yeah, exactly. That's a complete sitting job all day long. So if you see the medical assessment of what the judicial officers have across, now most of them have lumbar spondylitis, they have brain. I did not know before I joined judiciary and after I resigned when I speak to them, that there is a blood pressure in the brain too. And all the judicial officers have that blood pressure or the secondary post-traumatic
All that
stress.
blood pressure is coming from where? Because of high court judges.
I know coming from everywhere. It's the lifestyle that comes with it. So at 10:30, 7 o'clock you come home, and after 7 o'clock you eat your dinner, you have half an hour with your family, you sit on the next day's judgments. At 9 o'clock the police comes with a remand. At 1 a.m. in the morning you have to go to hospital.
I'm sure you must have been an outstanding judge. Trust me,
It's
I know a lot of judicial magistrates who are not working this hard.
Thank you everyone.
Thank you.
Thank you very much for being with us. Our next session is on September 13th. We are having the Ajay Gandhi Memorial Lecture by Ashok Lavasa. Thank you.